Getting started in just a minute. Thanks for joining, everyone. We'll be getting started shortly. Thanks for joining. We'll be getting started in just a moment. Hello, a very, very warm hello and aloha to many of us tonight. Thank you so much for joining for Ask Me, our educational webinar series. My name's Audra Hines, Vice President of Care Services for the Golden West Chapter of the ALS Association. We could not make programs like this one tonight even possible without generous donations to the Golden West Chapter. And I want to thank our lead sponsor for the Ask Me series, Mitsubishi Tanabe Pharma America, as well as our special donors, including the Ron Malone family and the Morris family. As a reminder of the Golden West Chapter's menu of care services, please remember we're always here for you. Whether you're a person who has ALS, a family member, a caregiver, a friend, or a healthcare professional treating someone with ALS, we offer a number of resources and supports. We're here to ensure that no one is alone in facing the challenges of ALS, and we're always a phone call, an email, or just a click away. We act with urgency as we serve our families and community through support groups, equipment loans, family support, one-on-one consultations, and much, much more. Whatever it is that you may be dealing with related to the disease, please just reach out. To learn more about the resources provided by the Golden West Chapter in English and Spanish, please visit our website, find us on social, or give us a call, and know that we're here for you. One of the most fundamental pieces of life, once we're adults, for anyone, anywhere, is financial and estate planning. This becomes even more critically important when someone is living with an illness. There are so many things to know and consider about documents to sign, people to talk to, what types of discussions to have. And in an effort to try and get as many of your questions answered tonight on this topic, we've invited a special guest. Kate Phelan is Senior Vice President and Regional Director of Wealth Planning and Trust Advisory with U.S. Bank. She partners with senior executives to collaborate in the areas of estate planning as well as wealth transfer needs. Kate began her career in the banking and financial services industry in 2015, and prior to joining U.S. Bank, she worked as an estate planning attorney. Kate, we're so happy you could be here and join us tonight and give our ALS community such valuable information. I'm going to let you take it away.
Thank you, Audra. It's a pleasure to be here. I appreciate the opportunity to be here with you tonight. As Audra mentioned, my background is in estate planning. So although I've worked for a big bank for a number of years, I got there by way of a very small law practice, was doing estate planning. And so hopefully nobody has too many questions tonight about credit facilities, because I don't know very much about banking, but I know an awful lot about planning. And the type of planning that I do with my clients, it covers a pretty broad variety. There's everything from, is there going to be enough money to retire? What happens to my kids if something happens to me prematurely? I want to retire early. How do I get there? I've had a major windfall. What will the tax implications be? Et cetera, et cetera. But at the foundation of all of that, for everybody, regardless of the number of zeros that are on your balance sheet, regardless of the complexity in your family circumstances, regardless of what you may be facing from a health perspective, estate planning, just that foundational, what's going to happen, I think it's absolutely critical for everybody. And so I really appreciate the opportunity to be here tonight. I hope that there will be lots of questions. I'm happy to be a resource after tonight. I know Audra's going to provide my contact information. So I'm going to start by sharing a slideshow, which I practiced earlier, so hopefully it'll go smoothly. And I'm going to start with, what are the documents of estate planning? But before I get into this is kind of the how of estate planning. I want to just talk a little bit about what estate planning is. It covers a couple of pretty important topics. It is the transfer of your assets when you pass away. And I think that's what we kind of generally think of estate planning as, right? What's going to happen to my assets when I pass away? Who's going to be in charge of making sure that that happens smoothly? So that's certainly part of it. We'll talk tonight a little bit about not only who is going to receive my assets, but how are they going to receive them? But estate planning is a little bit more broad even than that, right? It also talks about things that happen before you pass away. Who's going to be in charge if you become incapacitated? Who's going to make healthcare decisions for you? Who's going to make financial decisions for you? At what point do you want them to be empowered to make those decisions? So estate planning is really a pretty broad term for a lot of concepts that come into play. You can see here on the screen, this is kind of the basic suite, if you will, of estate planning documents. So if you're making a checklist of what are the things that I think I need to have executed, have a copy of, have somewhere safe, have given to the people who are pertinent to me, this would be a good place to start.
There is an exception. Sorry, just real quick, we're not seeing your slide advance. Do you want to go down and put it on full screen? It's just the little icon you see all the way at the bottom of your PowerPoint. It looks like a little TV screen on a stand, all the way down at the bottom.
Oh yeah.
That'll give you the full screen.
Is it this guy? No, that's not it.
Or if you want to just click to the next slide, you can. I just wanted to let you know where you're still on your first one. No problem either way.
I'm still on the first slide, so there should be 6 blue boxes.
Okay, I see fundamentals of estate planning.
Oh, shoot. Okay. Well, that's not going to work. Sorry, guys.
No worries.
Let me see. Can you see this?
There you go.
If I do it this way?
That works. Yeah, that works.
Okay, let's just do that. It's a little bit less tech savvy, but at least we can all see
No
it.
worries. That's perfect. Thank you. Didn't mean to interrupt.
No, I'm glad you did. And I made this joke earlier. I'm better at estate planning than I am at technology, luckily. So here on the screen now are what I would consider the foundational documents of estate planning. So again, if you're making that checklist, these would be some documents to say, okay, great. I know that I've got these, they're updated, they say what I want them to. The people who are going to need to be a part of that are aware of them, they've got a copy, etc. There is one exception, the revocable trust. It's can be a very critical element of an estate plan, but depending on the complexity of your assets, it may not be entirely necessary. And so that would be one where I think you definitely want to have taking care of having a will, financial power of attorney, healthcare power of attorney, and a living will. The revocable trust, that's going to be a perhaps. We'll talk about that, as I said. And then proper beneficiary designation is going to depend on if you have assets such as a life insurance policy, a 401k or IRA, or if you have other accounts that are going to transfer by a designation of a beneficiary. So we'll get into that a little bit, but this is just kind of a foundational checklist of what we're going to talk about from a document perspective. And the documents, as I mentioned, are, again, this is the how. The what is the decisions that you make about what you want to have happen for the rest of your life, and then upon your death, these are the documents that you use in order to implement that. For folks who don't do any estate planning and you pass away without a will or revocable trust, the state of California does have a plan for you. That's called dying intestate, and they will then make the orderly distribution of your assets, but it follows a pretty traditional family line. So it goes to a spouse, then to your kids, if no kids, then to your parents. And so for some folks that makes sense, but for most, we want to have a little bit more control over that process. So that's why we're here tonight. So let's talk first about wills and trusts. So like I said, the trust is something that is a really neat vehicle that can save a lot of hardship with regard to a process called probate. So probate is the process where the court says, this is what the orderly distribution of your assets is going to look like. So a will or no will, you're still going to find yourself in the probate court. And in California, that's a bit of a pain because everything is a little bit slow here, right? Because there's a lot of people here. It's been a hard few years. So the revocable trust is a vehicle where you can avoid going through the probate process. But ultimately, these two documents, everybody's going to have a will and perhaps a revocable trust. These two documents are going to be really critical for a variety of things. As you can see here from the chart, the one on the left being with regard to what a will does, the one on the right being with regard to what a revocable trust does, both are going to be a vehicle that you can use to say, this is how and where I want my assets to go when I pass away. So in that regard, they both can get that job done just fine. And you'll see I have a note here about probate versus non-probate assets. I'll talk about that in a minute. A will is really critical for a couple of things that you see here in the middle, right? This is the document where you're going to provide instructions about, would I rather be buried, cremated? Would I like to have my body donated to science, organ donation, things like that? So you can put a lot of thought into those things ahead of time and provide for them in your will. There are companies that you can engage with ahead of time where you can kind of pre-plan and pre-fund those activities as well. But it's good to have that shored up in the document so that your loved ones who are taking care of your estate when you pass away know this is how things should look. So that's an important one that the will provide for. The will is also the document where you most typically see an appointment for a guardian of minor children. So if somebody passes away and they've got a surviving spouse, of course, the surviving spouse is going to be the automatic guardian of the minor children. But if there's not a surviving spouse or the other parent is estranged, perhaps, you want to make sure that you've appointed who's going to take care of my kids if something happens to me. This is somebody that you trust to make sure they get the type of education, religious experience, lifestyle, things like that. It may also be the person that you appoint to be in charge of any money or life insurance proceeds that are left for the children. Sometimes I see folks bifurcate those roles, right? One person's going to be really in charge of raising the kids. Someone else will be in charge of the finances. I think that really is a personal opinion, but that's one of the levers that you can pick when you think about what am I going to do for my children. So that's a decision to be made there. You can see on the right, the revocable trust tends to be a little bit more robust from a tax planning perspective. So if one is married and there's going to potentially be an estate tax issue, or there are some family complications where we need to do some tax planning, the revocable trust tends to be a little bit more of a robust vehicle. That revocable trust is also a contract. So that means it does not need to be part of the probate system. So while both the will and the revocable trust can say, here's what's going to happen to these assets, the will would need to be probated through the courts, whereas a revocable trust does not need to. So that does make the administration a little bit more simple. But when you think about setting up the asset, or excuse me, when you think about setting up the documents and working with an attorney, the revocable trust can be a little bit more expensive from a planning, or excuse me, from a drafting perspective. And the revocable trust also requires to be funded. So that means you've got to go to the bank and say, you know, I no longer want my accounts in my name. I want them in my trust, my house, all of the stuff, which can be a really tedious project. So depending on where you're focusing your energy from a health perspective and other things that are going on, it may not be worth it, right? So that's one of the things where you think about, okay, do I want to do a revocable trust? It's a great vehicle, but again, not necessarily necessary for everybody. And then you can see at the bottom here, I've noted that both of the documents require that you have testamentary capacity. Public policy is such that we really value the ability to make these types of decisions for yourself with regard to the autonomy of your body, the appointment of your guardian, of your minor children, the appointment of how you want your assets to pass. And so testamentary capacity is a relatively low threshold, but it does mean that you need to have these documents signed before you've reached a point where you are incapacitated. And so for folks who are facing, for example, Alzheimer's, as my aunt currently is, there's really a rush to make sure that the documents are done ahead of time while everybody feels comfortable that the folks who are signing them are of sound mind. They both also need to be witnessed. They don't need to be notarized, but they do need to be witnessed. So just from kind of a how do we get there with these documents. I also mentioned this concept of beneficial designation. So this gets overlooked sometimes, I think. I see oftentimes in my practice this notion of, oh, I haven't looked at who the beneficiary on my 401k or my IRA or my life insurance is in a long time, or I haven't looked at, you know, how that split gets made or how it gets passed. So one thing that's important to do if you have any assets where there's a beneficiary designated, and that's a non-probate asset, that's an asset where that transfer is made just according to what the contract says, according to that designation. That's something that you want to make sure that you're comfortable with all of those designations and that you have a copy of. One thing that's important to note between your probate assets that are going to pass either by virtue of a will or a trust versus a non-probate asset is your will and your trust, you're going to appoint a fiduciary to be in charge of those documents, to be in charge of that estate settlement process and make sure that things go the way that you've outlined them to. So that's either going to be a personal representative, commonly called an executor, or a trustee. And that person's going to be in charge. They're going to gather the assets. They're going to distribute them. Assets that have a beneficial designation don't have a fiduciary that way. That's just a contract where the named beneficiary, if once they have a death certificate in hand, they call up the financial institution or the life insurance company and say, I'm the named beneficiary. My loved one has passed away. You know, what forms do I need to fill out in order to receive those assets? So a little bit simpler process, but a different process, a different number of people who are involved from that perspective. So not only do you want to make sure that you're comfortable with those beneficial designations, but I also recommend to the extent that you're comfortable or the extent that you believe it's time to, letting those beneficiaries know that you've appointed them there so that they know that it will be incumbent on them to deal with the financial institutions at the time that one has passed away. So those are the three avenues, if you will, or documents that we use in order to pass assets. And that's a really important part of estate planning, I think, because we think about, you know, who do I want to receive my assets? And assets is a bit of a broad term. And I want to pause here and talk a little bit about the types of assets that we look at. I mentioned that there's probate and non-probate, you know, right? What is something that you own and take title to versus something where you have a contract with a company and they're going to pass the assets. But it's also a pretty broad term in terms of, you think about real estate, you think about bank accounts or investment accounts. Something that I think gets overlooked an awful lot is the concept of tangible personal property. And that's an important one. And it's something that I really encourage folks to spend some time while they're feeling well to think about, of the things that I have that I perhaps have a sentimental value to, and certainly a financial value, but a sentimental value I think is even more important. Who's going to get grandma's china? Who do I really want to make sure gets my wedding ring? Or, the signed Beatles album, things like that. The way that I recommend that folks do that is that you make a list. And in listing the items, you use enough specificity that somebody who's never met you before, never been in your house, would know what you're talking about. So, for example, you don't say my diamond ring, you describe, its shape, how many stones it has, things of that nature. Using a picture is a really good way of doing that too. That document should be dated and signed, but it does not need to be a part of your will or your trust. You don't need to have an attorney draft that for you. It's something that you can do by hand or on your computer. I do recommend, as I said, dating and signing and keeping it with your other estate planning documents. And that's a really, I think, good exercise because, when you think about passing a bank account or an investment account, things like that, that's important. And there are implications to that. And there's legacy and, is there going to be enough and how's that going to look? Of course, it's critically important. But I think that the notion of how would I like for my tangible personal property to be distributed and enjoyed, there's some joy in that exercise and making some of those decisions. So that's something that gets overlooked an awful lot, I think. And I think it's probably one of the more important, particularly from an emotional perspective, parts of this whole notion of estate planning. The other thing that I don't think we spend quite enough time focused on is, and you've heard me say it already this evening, there is the concept certainly of where are my assets going to go? Who's going to receive my house? Who do I want to have the money in my bank account? Things like that. And it may be as simple as, it all goes to my surviving spouse and from there they'll make a decision, or it goes equally to my children and it's a relatively straightforward distribution. For folks who have a more complicated distribution, that's certainly up to your own behest, that you say I want to leave a certain percent to friends, to charity. Perhaps you leave it in different amounts to your children for whatever reason. If you have a child who's won the lottery, they may not need the money as much as perhaps a child who has some student loan debt or things like that. So those decisions also start to come to fruition when you think about drafting your will or your revocable trust, that orderly distribution of your assets. So to me, that's a lot about who's going to receive the assets or where are the assets going to go. Another thing that's really important to think about is how will those assets be transferred? And there's two kind of main options here, and there's certainly some nuance here that's beyond the scope of what we have time for tonight, but the two kind of main options are, the first is outright. Here is a check for all the money in my checking account. Here is the title to my home. Here is the title to my car, right? It's just an outright, now it belongs to you, Mr. or Mrs. Beneficiary. You have full control and access to do whatever you want or need to do with it. For minor children, of course, that doesn't make sense, but even in an outright distribution for a minor child, it would simply be held in an account until they reach the age of majority, and then they would have that money to use. The other option is to hold the assets in trust. I think we all know that notion of a trust fund baby, but I think that trusts can be really valuable vehicle in the sense that I've put some assets into a trust for your benefit. And when you need it for certain reasons, you can come to the trust to receive it. So, for example, you think about a child who's maybe in their 20s or 30s or 40s, and they have these assets that are available for them to say, I need a roof on my house, or I need to have knee surgery, or I'd like to go back to school, things like that. And the child can come to his or her trust and request a distribution, and a trustee who's in charge of those assets can say, yep, that's consistent with the intent of this trust, or the trust can't afford that, or, let's have a conversation about what that might look like. The benefit of holding assets in a trust, particularly for younger folks, is that it protects those assets from potential creditors, including a future potential ex-spouse. It protects the assets from the beneficiary themselves, right? If you think, well, maybe my child's not quite ready to manage the assets or to make these financial decisions, you can say, somebody who's going to be a little bit more financially responsible will be in charge of managing the assets, but they're there for your benefit. So I think that that's something that's really worth considering, is this notion of, is it appropriate in my particular case to use a trust for the benefit of my beneficiaries? So again, that kind of gets into not only where are my assets going to go, but how do I want them to get there? And I think that's a really important part of it. It's just when you start to think about how much control and access do I want my loved ones to have over the assets that they'll receive? And that's a deeply personal conversation. If it were up to me, everybody would leave all of their assets in trust for their kids, because this is California, where 60% of marriages end in divorce, and we have, crazy highway systems, and things happen, and there's a lot of creditor issues and what have you. So that's really an in the vacuum financial, lawyer decision. Do most people do it that way? I would say maybe a majority, but not an overwhelming majority. It's deeply personal. Another thing that I like to encourage people to think about is think about your financial values. If you do decide, I'm going to leave this money in trust for my children, think about some direction to the trustee of how you would have spent this money for your children had you lived. So by that way, I mean, direct the trustee to say, this is money that I want to be used for a wedding. This is money that I want to be used to help my child buy a first business, or make a down payment on a home, or take a trip to Hawaii. Things that, had you lived, you probably would have given your child money for. I really appreciate when trusts are drafted to give the trustee or the executor of the estate some of that direction, because it's a really nice way for your financial principles to live on in the planning that you've done. So that kind of covers the first big element of estate planning, which is the orderly distribution of your assets. Now, and maybe I should, in hindsight, do this presentation in reverse, because the rest of estate planning is really about the things that happen before you pass away. And there's a couple of important documents that govern that. The first is the financial power of attorney. And this is a document that I think that we're all at least aware of generally. I have here on the screen 4 different types of financial power of attorney. But generally speaking, a financial power of attorney is a document where you appoint another individual to step into your shoes with regard to financial decisions. And it may be all financial decisions, or it may be limited financial decisions. And I'll get into that in a moment here based on the different types. But this is an extremely powerful document. I will tell you, working for a federally regulated financial institution, we are terrified of financial powers of attorney, because they vest in another individual a tremendous amount of authority over your financial well-being. And so it should not be taken lightly who you appoint or under what circumstances you appoint them to serve on your behalf. Now, for as serious as it is an equally important document, because this is the document where if you become unable to make sound financial decisions for yourself, you want to make sure that somebody can make those decisions on your behalf. And you can't just walk into a bank and say, my friend or my dad needs me to make these decisions, right? We really need to have that evidenced. So this is a critically important document to have. The types of decisions that a power of attorney may apply to would be anything from, we're going to sell this home, to we're going to make gifts of cash, to we're going to make, investment changes in an IRA account, things like that. So it can be a very broad document. You'll see here the first 2 boxes, springing and durable. A springing financial power of attorney is one that only becomes effective when the principal who's appointing the power has become incapacitated. So today you've got your wits about you. I don't want anybody else making financial decisions for me right now. But if tomorrow something happens and I become, declared incapacitated, then instantly it springs to life. The agent that I've appointed is then automatically going to have the power to serve as that financial power of attorney. On the flip side, a durable is one that becomes effective the moment you sign it. You sign it today, tomorrow morning, the person that you've appointed can be making decisions on your behalf, whether or not you've lost your capacity. So that's a really important distinction there. I typically see between spouses and certain parent-child relationships that durable, but otherwise I'm a big fan of that springing power of attorney. You'll see the last two boxes have more to do with the scope of the power of attorney. That general is going to be a really broad, this person can do anything for me. The limited is going to be, I'm appointing somebody who's going to have very limited authority to sell this house, to make decisions on this one account, to make decisions on one aspect of my financial well-being. There is a form, California has a form financial power of attorney that lists a number of things that you might be able to do, right? Everything from selling real estate to buying a new car, et cetera. I think it's about 25 items that it enumerates on the form. And you can go through and really just honestly write an initial or a checkbox. These are the things I'm granting, or the last option is I'm making a general grant of all of these. So the financial power of attorney is a critically important document because of that form that the state of California provides. It's not one that I find necessary to have an estate planning attorney draft for you. Although that said, if and when you meet with an estate planning attorney to do some of these other documents, this financial power of attorney is generally a part of that suite or set of documents that you're purchasing from the attorney. So you might as well have them draft it for you and go over it. But one that is relatively easy to bring to fruition for yourself. And again, really critically important. Then the last two documents, we're going to navigate away from the financial side of estate planning, right? Everything we've talked about so far has really had to do with your financial well-being. Who's going to get my money? Who's going to control my money while I'm still alive? All of those things, which obviously I find important. It's a really critical part of all of this. But the last two items I think are probably the most important, and not probably, certainly are. And those documents are the healthcare power of attorney and the living will. Oftentimes I see these two documents mushed into one. That's just a planning preference depending on the attorney that you've used, or if you've used a form through a hospital network. And a lot of the hospital networks here in California have good forms available for patients and for folks. So it's really more of a drafting preference whether or not they're two separate documents. You also sometimes see these referred to as healthcare directives, other titles like that. But the concept is as follows. The healthcare power of attorney, much like the financial power of attorney, is a document where you're appointing somebody else to make healthcare decisions for you. Now, this is not at a point where you're sitting in your doctor's office and you understand what your options are and you're making decisions for yourself. This is you have become either mentally incapacitated and therefore cannot make decisions for yourself, or for example, you've been in a bad car accident and this is not an end of life decision, but this is just you're in a bad spot. We've got a couple of medical options for you, which is going to be the one that you want, but you are unable to make that decision. Who is the person that you want to be appointed at that time? This is a really important one, and this is one that I think is hard for people. I oftentimes see clients say, I want it to be all three of my children. That's pretty tough to get all three kids to agree, to get them all to be in the room, to sign off on something. So both emotionally and administratively, I really encourage folks to pick one person and then another. And then I encourage them to have a good conversation about these are the people who I want to be helping to make these decisions, but that you're really empowering one person to be in charge of delivering that message with the doctors. I also really encourage folks to think about somebody who's going to be a good advocate on your behalf in the healthcare delivery system. Unfortunately, I don't have to tell those of us who are on the call tonight that the healthcare delivery system can be very difficult to navigate. Doctors become so afraid of their legal liability. There's not a lot of time. So you want to make sure that you have somebody who can really navigate that system, who can be a good advocate for you, who can make good decisions. I oftentimes talk about my dad. My stepmom is certainly appointed to be his healthcare power of attorney, but I'm pretty sure vice versa, she has my stepbrother instead of my dad, because I think my dad would just be totally paralyzed by making decisions, wouldn't be able to deal with the doctors. He's got other strengths, but I really encourage you to be thoughtful about who that person's going to be. It is important to note that for those who are married, your spouse does have automatic legal authority to make those decisions. But to the extent that you're appointing a friend or a sibling or a child, that authority is not automatic. I do also really recommend that the person that you've appointed, and I should have said this with the financial power of attorney as well, is that the person who's being appointed as your agent has a copy of the document, so that if something happens, they can walk into a bank or a hospital or another situation and say, I have this authority and here's my proof of it. By that same notion, I recommend updating those documents at least every few years. So if you did estate planning 20 years ago and you look at it and say, yep, this is all still great, that's great. But I would really still recommend that when it comes to the powers of attorney and the living will, which I'll talk about in a minute, that you update those documents pretty regularly so that the financial institution or the healthcare institution that you're dealing with knows that they're not stale documents, that they're still relevant to your wishes. And then the last document is the living will. This is the document where you make the decisions for your end of life care, something that is deeply and profoundly personal. And there's absolutely, of course, no right answer. But really, in my opinion, cannot be overstated the importance of having this document. This is where you can outline, yes, I want to be kept alive for as long as possible. Please do everything that you can. Or I want to be kept alive under certain circumstances, but not others. So if I'm in a vegetative state, for example, versus being in a locked in state, just as an example. Or you can say, you know what, at some point, if it's determined that there's no quality of life to be had, I would like, for no more efforts to be made to keep me alive. Again, deeply personal, but a really important document to have. With regard to all of these documents, we've kind of walked through how do I do the estate planning. One thing that I oftentimes see get forgotten is who do I give the documents to? It's really important that if you've appointed somebody to be a fiduciary for you, so that's your executor of your estate or a trustee of your trust or one of your agents under a power of attorney, make sure that they have a copy, that they understand what's being asked of them, that they understand under what circumstances they would need to act, make sure that they feel comfortable, that they have the documents, that they understand how to use them, that they're keeping them in a safe place. If you have the originals of your estate planning documents, those should be kept in at the very least, a safe drawer at home. A fireproof safe is even more ideal if you have space for one of those little ones. I have mine in a fireproof filing cabinet. So it's important that somebody else know where they are and have a general idea of what they say. I also think that it's important to have certain discussions that you want to have. And that's a little bit vague way of saying that I think that's a deeply personal conversation. I have clients ask me, well, should I tell my kids all of this? And I tell them, that's up to you. Some families are really open about financial decisions, about the decisions that they've made with regard to their end of life care, things of that nature. And they want to be really open and upfront and say, the accounts are at Wells Fargo and this is how much is in them and so on and so forth. Other families don't, right? They don't want their kids to know too much too soon. And so I think that that's something that is really a choice for you, but it's one that I encourage folks to make, right? Or do we want to keep this a secret? Do we want to be open? To what extent? And to have some of those conversations, early and often while you can. Maybe not often, but early while you can. So that the people who need to know what they need to know about your estate planning do while you're still in a position where you can have a good, meaningful conversation about it with them. Unfortunately, I all too often, because my practice also includes the administration of estates, I oftentimes get involved with families in the wake of a loved one passing away. And when there is not a good plan in place, it's very difficult. It's really the most profound insult to injury that there is. But I can't tell you how many times we've been looking for the documents, or we've been looking for, the life insurance policy, or we've been looking for the list that we know, says what should happen with grandma's china. So a little bit of organization is kind of that cherry on top for having made the effort to make all of these plans be put into place. So I think with that, maybe it's just about 20 before the top of the hour. Maybe I'll take this screen down, and if we have any questions, I can field them now.
That's great. Thank you so much, Kate. That was wonderful information, and you chalked a lot of stuff into that. I really appreciate it. We do have a couple of questions, and I just encourage anyone else who has questions to please put them in the Q&A function too. We'll be sure they get answered. The first is, what are some affordable options for setting up wills or trusts if you can't afford to hire an attorney?
Absolutely, absolutely. So believe it or not, and I probably wouldn't put this in writing, but LegalZoom is actually a really good option. They have some nice form documents that can lead you along the process of, here are the decisions you need to make in this document, and here's the implication of the decisions. To get a package, I haven't looked recently at what their fees are, but for a few $100s, you can get some good, nice forms that'll also include the directions on execution. The other thing that is important to think about is, depending on what one's assets look like. I talked a little bit about designating beneficiaries, and in the state of California, you could, again, depending on the complexity, if you own a business, for example, this doesn't apply to you, or if you have a lot of income producing real estate, probably doesn't apply to you. But for folks who have, a home or some bank accounts, things like that, making a beneficial designation is an option that's available for any type of asset, including in California real estate. And that's where you can literally just walk into the bank and say, I'd like to make this account a payable on death or transfer on death account. And so without doing any will or trust, which please still do a will, because I think it's very, very important. But to really minimize how much money you need to spend on the will, you can shore up a lot of your planning by doing thoughtful beneficiary designation on any of the assets that you own. Really, like I said, with the exception of a business or a complex real estate empire, so to speak. But
Okay,
LegalZoom would be the best one, in my opinion.
Okay, gosh, that's really helpful. Kate, you probably know that we have people on the call and in our chapter service area that are in both California and Hawaii. We have a question that asks, do the states of California and Hawaii have any way for people to register that they've created financial or healthcare powers of attorney?
That's a really good question. So there isn't so much a registration, as much as what I encourage people to do is look at the institutions with whom you're engaging. So if a client of mine has appointed a power of attorney, a financial power of attorney, I ask that they let me know, hey, by the way, my son is appointed this way. This is valid. I want you to know that I've made this appointment. The financial institution is required to keep that confidential. So I can't call up the son and say, hey, get a load of what your mom's done. But it does put us on notice that if something is to happen, that this is the person who does in fact have a valid power of attorney. The same goes for doctors. I really encourage folks, you're working with a group of professionals who are helping you with your health. Put them on notice. These are the people that I've appointed this way. Is there a discussion that needs to be had? So it's less about registering it with the state and more about making the people who might actually need to transact on it aware. Now, that's problematic for people that you're not doing business with, except to the extent that if somebody walks into another bank and you don't have accounts there, well, then so be it. So if you really keep track of the folks that you're doing business with and let them know these are valid, that's a really good first step.
Okay, great. I hope that answered that person's question. If not, feel free to type in another one. What's the advantage of having an irrevocable trust? Why would someone choose this?
Does the question say irrevocable, or is it the revocable trust that I talked about today? Maybe someone could type in just real quick.
Well, it says irrevocable.
Okay, great.
Yeah.
Both really valid questions. Wanted to make sure I was answering the right one. So irrevocable trusts is a really broad umbrella of trusts that people implement, generally speaking, for two reasons. The first is tax planning. For folks who have a net worth in excess of $12 million as an individual, or about 24 as a married couple, the irrevocable trust can help you do some really good planning from an estate tax perspective, where you can give some gifts away, get them out of your estate, help mitigate that estate tax. Irrevocable trusts are also oftentimes used after one's passed away. So I talked about that notion of leaving assets in trust for your children. That would be an irrevocable trust. Your kids can't go in and change that trust that you've created for them. And the benefit of that is exactly that, right? They can't change it. They're bound by the decisions that you've made. So there's tax planning, and then there's kind of this notion of using an irrevocable trust to protect the beneficiary from creditors or from his or herself. There is a third avenue of that umbrella, which has to do with asset protection planning. But for as sexy and cool as that sounds in a James Bond movie, it's a pretty limited avenue. So if anybody's got a specific question about that, that would be one we could take offline. But the IRREV trusts tend to really fall under the category of estate tax planning, or this is a vehicle that I'm using so that the assets don't go outright to my kids or other loved ones. I keep saying kids, but any general loved ones. Okay.
That's great. There aren't any other questions in here. So again, I just want to give everyone a last chance to type things in. But, Kate, one thing we get asked a lot is, for people who may not have much money, right, in their lives, maybe don't have many assets. I think there are times when people assume maybe, I don't have much, I don't need to set some of these things up, right? Because I'm not sure how much I'm really leaving behind. How would you advise people who maybe are thinking that way?
Yeah, to me, estate planning is for everybody. And I do think, there's this sense of it's really only about having a big estate. And with the estate tax exemption as high as, $24 million, come on, how many people are really impacted by that? It's easy to say, I don't need to do any of that. It doesn't pertain to me. But think about some of the decisions that we've talked about, right? Things around the assets that you feel sentimental about. Things around, do you want to be buried? Where do you want to be buried? Now, there are other ways besides a will that you can do that, right? You can go down to the cemetery and make those arrangements and provide that information to your family. But at the end of the day, not having that will as a backstop tends to just create problems for your loved ones who are trying to get anything tied up. And it doesn't have to be a lot of zeros of what they're trying to get tied up. It's really about making things a little bit smoother and easier for the folks who are left behind. But I just think that the scope of decisions that go into estate planning, it's too easy to get it done. Really, honestly, you could write yourself a will on a piece of paper and sign it, and you could make that work. I don't encourage people to spend a lot of money unnecessarily on it, right? It can be a daunting price to go see an attorney, but things like LegalZoom, things like looking at some documents, online. The internet is a pretty cool place in terms of information. Just make sure you're using a good source. And what I would just encourage folks is, okay, if you say, I can't afford to do any of this with an attorney, what are some of the other ways that you might shore it up? How are some of the ways that you might document these decisions so that you don't leave a loved one in a mess of saying, well, we really know that they wanted X, Y, and Z, but we have no way of making that come to fruition. Or we don't know what X, Y, and Z is. We don't know what they would have wanted. And so now we're forced to just make whatever decision we can or we think we should.
That's really helpful.
One other thing, actually, and I'm sorry to interrupt, Audra, but just kind of came to me is there are some volunteer estate planning organizations, and I don't have the contact information, but I could follow up, There are some organizations or firms who will do, pro bono or discounted estate planning under certain circumstances if the individual, doesn't have the means to otherwise engage. And so looking for those types of resources might also be valuable. Again, depending on the complexity. I mentioned earlier this notion of using beneficiary designations and some other documents and shoring it up with a basic will. That's not the most complex, but it gets the job done, right? And so when you just think about what are the decisions I want to make and how do I document them, that's what's really critical. But there are some good resources out there who may be able to provide some discounted legal services, if you will.
That's great. And I'll ask somebody on my team, Kate, to just put your email in the chat too, if anybody has follow-up questions, just wants to find out about any of that. We've had a couple of other good questions come in. Any special considerations required if beneficiaries live abroad?
Oh, great question. The short answer is no, other than I would make sure that you understand how they prove that they are who they say they are. So in the United States, we use a social security number. Other countries typically use a like number, but if you're going to appoint somebody who's abroad, in that beneficial designation form, make sure that you include as much specificity about who they are. So this is Kate Phelan, who lives in Barcelona, Spain, and here's her, identification number and address as of this date, things like that. So that there's enough specificity, because a financial institution is going to say, ooh, how do we prove that this person is who they say they are? So if you've kind of self-proved ahead of time, that will help wrap it up for them.
Okay. That's great.
But great question.
Yeah, great question. How about this one? Do you have many conversations about giving to charity in your practice?
I do. Yeah, I have a lot of those discussions. There are a lot of options around how you give to charity. You can make them the beneficiary of your estate, which is as simple as saying, when I pass away, I want 25% of what I have to go to the Boys and Girls Club or United Way or, whatever your favorite charity is. There are some other more complex options depending on what one wants to do. But certainly when you think about beneficiaries, charities are oftentimes part of that. I oftentimes see folks want to give back to organizations like this. It's an organization that's really impacted you, that when the time comes you pass away, you want to make those gifts. So if somebody wants to talk a little bit more about some of the options of how that looks, happy to, but that would be another great thing to do. And you can appoint a charity by beneficiary designation. I hate to sound like a big champion for designating beneficiaries, but it just tends to be a really basic way to get things done. That goes for individuals and charities.
Okay, great. This question is very relevant to some of our ALS community. This person says, if I cannot speak anymore and I'm unable to sign documents, how can I begin setting these things up? We certainly have a number of folks in our community who use communication devices. Maybe they can't verbally speak anymore, but they can communicate in other ways. So just asking around that.
Yeah, absolutely. And good question. The thing about estate planning is if you can communicate your desires, they can be drafted into existence. So if that needs to be done entirely via email or via a communication device, certainly that could be done. I would recommend that you ask an attorney, is this something that your practice can easily accommodate, or that you have somebody with you who helps accommodate that communication for you. But certainly that would not be, the inability to speak would not be considered incapacitated such that you can't make those decisions. And just to kind of put an underline on that, you have to be at a place where you do not understand who your family is. I mean, even remotely understand who your family is, or who you are essentially, or what you have in your universe, before you're deemed to be incapacitated. Now, it's more complicated than that, but my point is that people, I think, sometimes say, well, mom's lost it. She can't do any of this. And the reality is probably that mom hasn't really lost it relative to estate planning yet. And then in terms of signing documents, if one's not physically able to make their old signature, truly just placing an X or some other mark that's intended to be their signature does incidentally rise to the relevance of being the signature. That's when it's really important to have a witness, and to have witnesses who understand this is how this was communicated, this is why this is not a signature, who can shore that up. The more that you can evidence that, the better. And really, that's if you're worried that people are going to say, no, I was meant to get that, it's not somebody else. But yeah, communication would not be a barrier to having requisite capacity.
Okay. I hope that helps answer that person's question. I'll give everybody just one more minute to type in any last questions. And I know we put Kate's email into the chat too. If you have anything specific for her that you'd like to reach out directly to her about, that's great. Kate, this has been amazing information, and I love that we've recorded this and we're going to have this for a long time into our library of webinars that we offer through this Ask Me series. So thank you so much for being here. This has been great.
Thank you, Audra, for the opportunity to be part of such an important series. It's been my pleasure.
Absolutely. And we'll pop up our closing slides. I just want to thank so much. Big thanks to everyone for joining us tonight. We are so grateful to each of you for your time and commitment, for being a part of our community. Once again, a big thanks to Mitsubishi Tanabe Pharma America for their support. We have lots of good stuff coming up in August and September, so mark your calendars. If you like to Zumba, August 21st brings our Hawaii Walk to Defeat ALS Zumbathon, and August 24th will be a fun evening focused on kicking off our fall events. For the golfers out there, we have the Peterson Golf Classic upcoming on September 12th, and we have more upcoming in September with events in Hawaii and the California Central Coast, and our Napa Valley Ride, Hike, and Walk. Please join us for any and all of these fun-filled, family-friendly events, either in person or via our virtual options. There really is something for everyone, and we want to welcome each of you there. As you know, philanthropy fuels everything we do, and we're grateful to committed donors who give generously throughout the year. To learn more about how you can support the valuable programs we offer, including programs like this one tonight, please visit our website at give.alsagoldenwest.org. And please download a copy of the Golden West Chapter's free estate planning guide at alsgiftplanning.org. Watch for the short survey on tonight's presentation that you'll receive in an email to help us plan for future educational programs. Thanks so much again, and stay cool out there.